Well, we're here to talk with you today about an interesting case that came out in December of 2020. It was a nice holiday surprise for all of us that it was handed down by Delaware. It kind of flew under the radar a bit until it started getting picked up, but I'm glad we're here to talk with you because it does have the capability to impact how companies communicate with their board of directors. And it could impact things, especially when it comes to things that are attorney-client privileged and especially sensitive. Well, Susan gave us that wonderful introduction, so we can skip our introductory slides and move straight into our overview. But we have planned for you today a little bit about background about privilege. I know that a lot of you all are going to be transactional lawyers and may not have thought as much about attorney-client privilege, perhaps since the days back in law school. So Billy is going to give us a good overview for what privilege is and how we can maintain it. Then we'll talk about the new case in Delaware, the WeWork case, and how it impacts communications with outside directors, especially on sensitive matters. And then to the extent that we have time, we will talk with you about communications in other contexts, about privileged information, including with shareholders and board observers. At the end, we will try to answer as many questions that we can. So we have set aside a few minutes of time at the end for a Q&A. Please go ahead and submit things to us through the chat feature if you can, and we will be happy to answer whatever questions we can get to. All right, well, without further ado, I'll turn it over to Billy to give us our overview on privilege.
Thanks, Matt. Thanks, Susan, for the wonderful introduction. Truly appreciate that. Like Matt said, I'll run us through a quick primer on privilege for those of you who are not in the thick of litigation every day and thinking about privileged communications all the time. So as you all know, attorney-client privilege protects from disclosure in litigation or otherwise certain communications with attorneys. It's not all communications. It's those that are for the purpose of seeking, providing, or facilitating legal advice. The communication must be kept in confidence for it to remain privileged. So disclosure to third parties, even if inadvertent, typically results in a waiver of the privilege, and then those documents are fair game for litigation. Who are the persons within a corporation that are covered by the privilege? There's a couple different tests out there. The majority of jurisdictions apply the subject matter test. This was described in a famous Supreme Court case called Upjohn. Essentially, if an employee communicates with corporate counsel within their role and in a matter related to the subject matter they deal with as an employee, the communication can remain privileged. Subject matter test or control group test is a much more narrow application of the privilege. It protects only communications between high-level corporate officers and corporate counsel. And this can cause all sorts of problems and be very difficult from a practical perspective. Luckily, not many states observe it anymore. And in particularly here in Texas, it's not the test that is applied. Under Texas law, the subject matter test will apply. And so luckily, we don't have to deal with all those issues with the control group issues as often, but it is important to note it doesn't apply in litigation in some different states still. And just as a reminder, that last bullet, it only protects communications. Just because someone tells an attorney a fact doesn't mean that fact is protected from disclosure. Work product is a separate doctrine. It's related to attorney-client privilege, but it protects materials that are prepared in anticipation of litigation. For example, notes that are prepared by employees at the direction of counsel to assist the lawyer in litigation. Those are protected by the work product doctrine. This is a specific litigation-specific, it's a litigation-specific protection. And attorney's notes about a transaction, for example, which you might think of as attorney work product, is not covered by the work product doctrine. It's intended to protect the adversary process and litigation generally, and it again doesn't apply in the transactional context. And there are some exceptions where an opposing party can get documents that are protected only by the work product doctrine, but those exceptions are fairly rare. There has to be a substantial need shown by the other party. One thing just to note quickly about work product, if you're starting to rely on work product privilege to protect your communications, you usually need to make sure you are preserving documents as well. Typically, document preservation obligations are triggered by anticipated litigation, which is also a requirement for work product protection. Sometimes parties get in trouble when they start to claim work product over documents, but haven't at the same time preserved or complied with document preservation obligations. I mentioned earlier that disclosure to third parties typically waives the privilege. There are a couple exceptions to that. One common exception is the common interest doctrine. This goes by several different names, community of interest, sometimes it's referred to as joint defense, but for today's purposes, we'll refer to it as the common interest doctrine. And this protects communications, privileged communications shared with third parties if the third party shares a common legal interest. This is a frequently invoked exception, but its application is hardly uniform among jurisdictions. There's a lot of confusion over what the common interest doctrine actually covers, and it can vary by state to state. Just as an example, and we'll go to the next slide for this, there's kind of two approaches among jurisdictions to the common interest doctrine. Some take a very narrow approach. Texas, for example, there is no common interest doctrine protection over documents shared with third parties unless there is pending litigation. So if there are documents that are shared outside that context, the common interest doctrine doesn't apply, and those documents, the privilege over them might have been waived by sharing with a third party, even if there's some other common interest among the two parties. And New York has a similar requirement, requires pending or anticipated litigation, so a little broader, but not much. And then federal courts, some federal courts apply it more narrowly. Here in the Fifth Circuit, which Texas belongs to, there has to be a palpable threat of litigation. Some states take a broader approach. Delaware is one of those. Communications don't have to relate to a pending litigation, and there doesn't have to be pending litigation, but you do have to have a shared legal interest, which is defined differently than a shared commercial interest. But Delaware courts have been known to be expansive on the application of this doctrine, and so communications that are shared among third parties, if they have a common legal interest in a transaction, the disclosure of those documents to third parties with common interests can be protected by the common interest doctrine. And a lot of states follow the same approach, and a lot of federal jurisdictions do as well. A lot of times, parties will rely on the common interest doctrine in the transactional context. For example, if there's three parties to a deal, and two parties are on one side and sharing, and their attorneys are communicating, they'll rely on the common interest doctrine to protect those communications. This is a little bit outside my wheelhouse from a practical perspective, because I'm not involved in all that many transactions. So I'm going to turn it over to Matt to talk about some steps you can take to better protect communication shared among parties with a common legal interest in a transaction.
That's a great overview of privilege. And it's an interesting topic on how you try to protect it when you're actually in the context of it. As Billy mentioned, there are a couple of jurisdictions that are more favorable than others. So one option is to try to make sure that your documents are governed and the choice of law for your documents is in a favorable forum. A lot of the deals that we do in the Texas market are going to be governed by Texas law. Some are governed quite frequently by New York law, especially when it involves securities. So those forums are not as favorable as some others. Delaware is one that can be favorable, but it's not a fail-safe in order to choose the forum of Delaware. There are cases in Delaware that have not been helpful in that context. So it can be a helpful point, but it's not going to be a fail-safe. So just know that choosing that correct forum or the best forum for you is not always going to get you where you want to go on this. Another thing that can be done is to try to couch any disclosures that are going to be made to being in connection with a pending or reasonably anticipated litigation. There are, you can put very favorable language in there that's self-serving in documents that helps to show that it was a present expectation of litigation, and that can try to help. You can also enter in confidentiality and common interest agreements with parties to, again, help buttress that argument that it's in connection with pending or recently anticipated litigation. And another approach, instead of providing information that could be deemed to be privileged, is to provide non-privileged information and allow the other side to make its own assessment. I know that's not always possible in connection with a transaction. A lot of times when there is something that is privileged, the parties want to talk directly about what is privileged, especially in an M&A type transaction. So it's in that context, it may not always work, but of course, just allowing the other party to come to its own conclusions can help obviate some of the need to disclose privileged information. I always recommend trying to talk about things as opposed to exchanging things that are written. Having a written record of what was exchanged, and for example, emails, they have a complete copy of what was exchanged, exactly the context, and it's always easier to obtain an email than if the parties were to talk orally about something. And it's always important to go back and exercise caution when you're disclosing information that may be privileged, because you want to know what's in there. Emails contain lots of attachments, so it's very important just to focus on what all is included in that email so you don't inadvertently disclose something that you weren't planning to do. All right, next we'll turn it back over to Billy to talk with us about another method of trying to protect privilege, which is joint client privilege.
Thanks, Matt. And this is just another exception to the general privilege rule that communications shared with third parties, the privilege over those documents is waived. The joint client privilege applies when two parties have the same attorney on the same subject matter. Usually this requires some sort of written agreement or engagement letter reflecting the joint client relationship. That's not a requirement, though. It can be implied from fact. You probably don't want to be relying on the joint client privilege unless you have some sort of written agreement in place, or there's some other obvious signal that two parties are jointly represented by the attorney, for example, a corporate holding company and a subsidiary. Just as a note, joint client privilege and representation can often lead to difficult ethical issues. And then another related topic here is that communications shared between joint clients under the joint client privilege can still be used against each other in future litigation. So the privilege doesn't apply. You can't assert privilege if you are in litigation with your co-client and it relates to the subject matter of that representation. And this arises sometimes when a subsidiary is sold off to another company or spun off into its own entity, and it can get very messy. But this is wanted to note that this is another exception to that disclosure rule. All right, so we'll dive into the WeWork case now after we've gotten that primer out of the way. As Matt said, this was issued just a few days before Christmas, so it flew under the radar a bit. When everybody settled back in after the holidays, read the opinion, we realized it had some far-reaching implications and may change how companies communicate internally, and in particular with outside directors. Let me start with a factual background of the case, just real brief. So SoftBank entered into an agreement to consummate a tender offer. SoftBank would purchase up to $3 billion of WeWork stock from the WeWork founder and other stockholders. The deal fell through. WeWork and the stockholders sued for breach of the agreement. So fairly simple so far. This is kind of where it starts getting complicated. SoftBank had a significant equity stake in WeWork already. It also owned approximately 84% of Sprint. Several SoftBank document custodians, the people who are relevant in the litigation, in other words, wore multiple hats. They had dual roles for WeWork and Sprint. While they were consulting with SoftBank on WeWork related matters, there were 2 Sprint employees that had roles at SoftBank that communicated with in-house and outside counsel for SoftBank using their Sprint issued email accounts. So you have 2 Sprint employees, they work at WeWork. 2, they were using their Sprint emails for WeWork. They worked at SoftBank too, and they were using their emails for the WeWork deal. Hopefully that all makes sense so far. None of these emails dealt with Sprint. They didn't relate to any Sprint business interest or legal interest. Sprint wasn't a party to the litigation and didn't really have any interest in the litigation at all. Sprint's code of conduct, and this is pretty much true of every major company out there, and any employer really, banned use of company email for non-Sprint purposes, and it reserved the right to monitor Sprint email and emails going through Sprint servers for whatever reason they chose. Plaintiffs had a couple clever arguments. They moved to compel production of approximately 89 documents that were sent to or received by these Sprint email accounts for these 2 dual SoftBank Sprint employees. And SoftBank had withheld these documents previously on privilege grounds. WeWork argued, and in the plaintiffs in this case, WeWork and WeWork stockholders, they argued that these communications were not confidential. As we discussed earlier, if they're disclosed to a third party, communications, so any privilege that applies to communications without counsel is typically waived. WeWork argued that these documents were no longer confidential because they passed through the Sprint email accounts and Sprint servers. Sprint had access to them. They reserved the right to review them. And so WeWork argued privilege had been waived. So what happened? WeWork and the stockholders won. They were able to compel production of the documents that passed through the Sprint servers. The court looked at the analysis like this. Did the Sprint employees have a reasonable expectation of privacy when using their Sprint email accounts for SoftBank purposes? If not, the documents were not confidential and they were not privileged. So the court, to determine whether there was a reasonable expectation of privacy in these communications, the court applied a 4-factor test from the employment law context. This was typically applied previously when an employee was suing their employer and had communications with their own personal attorney on their work email. So a little different context here, but the court applied the same test. Does the company maintain a policy banning, and this is a 4-factor test, does the company maintain a policy banning personal or other objectionable use? Does the company monitor the use of employee email? Do third parties have a right of access to the computer or emails? And did the company notify the employees of the use and monitoring policies? The court found that Sprint did just that. It warned employees that that Sprint would monitor email. The court found it did not matter if that these accounts, and specifically for these 2 employees, weren't monitored or actually reviewed. The fact that Sprint had the code of conduct that warned employees of email monitoring was enough. And it also noted that these 2 Sprint employees did not take any steps to defeat Sprint's access through use of a different email account, such as a WeWork email or a SoftBank WeWork account, or try to encrypt their communications. And the court found that these employees were also aware of the email monitoring policies. And so privilege was waived. This has far-reaching implications, but it's just to set this up, how does this usually come up? So, because some of you may be wondering, how did the other side, how did the WeWork and the WeWork stockholders know that there were privileged documents that passed through these Sprint email accounts? So we wanted to give you a primer on how this typically comes up for those not knee-deep in litigation. In litigation, you typically have discovery come into the company. The discovery asks for certain documents, and usually they're worded broadly, so it's all documents relating to a certain topic. You could also have third-party subpoenas that go to the outside directors or their employers or other companies that have some sort of relation to the case, and the parties can get those documents in discovery that way. But when a party withholds documents on privilege grounds, it has to produce a privilege log. And the privilege log identifies each document that has been withheld by some number or some other identification mechanism, and reflects various pieces of data. And now when e-discovery is so prevalent, metadata. So it'll show it'll have a document number, it'll show who this email was sent to, who it was sent by, who was copied on it, what the subject was, document title, the author, date, time, etc. It varies in different cases, but you kind of get the picture of what type of information is provided in a privilege log. In big litigation, like this WeWork case, there could be tens of thousands of entries on this privilege log. So what happens when a party receives a privilege log, they'll start to review it to see if the opposing party withheld any documents inappropriately. And they'll have someone look at it line by line and see if there's any reason to believe that the privileged document that's been withheld is not actually privileged. So one of the things people usually look for when they're reviewing a privilege log is if there are any third-party email accounts, because that makes for a good waiver argument. And that's probably how I'm not real sure how the documents in the WeWork case were found. I'm guessing that's what happened is they reviewed the privilege log and saw Sprint email accounts and said, hey, we may have a waiver issue here. So that's kind of how this issue comes up. Now, discovery dealing with outside directors can be complicated. The company may not have easy access to documents for outside directors. And so it may not be entirely clear what documents are out there. Like I mentioned earlier, the outside director employer may be subpoenaed personally. And then outside directors and their employers, if they're using their employer's email account, they have some reticence to produce any documents because the company, their employer may have privilege and confidentiality issues if they own it. So, and one thing I should mention is that we found in our litigation practice here that the use of third-party email accounts is particularly prevalent among outside directors. And so this issue this WeWork case gave us a lot of concern because we thought, there are a lot of sensitive documents and sensitive privilege communications going to the board and directors. And if they are going to outside directors' third-party email accounts where they're using their employer's email or some other email that passes through a third-party servers that the company doesn't have control over or the individual doesn't have control over, there's likely some monitoring policy that applies. And there's a chance that in litigation, an opposing party could make the argument that privilege has been waived because the outside director was using a third-party email account of their employer or someone else. So you can kind of see the far-reaching implications of this decision just from that. Use of third-party emails can really cause problems, and this is a practice of many outside directors. And it's also an issue that comes up when you have employees playing dual roles at various companies, or if you have a portfolio company and one of the private equity managers is using the private equity email. Now, it gets a little complicated, and there's some nuances to all this, but that's kind of the issue here. A couple other points to put this decision in perspective. This was a decision from the Delaware Chancery Court, which is a well-respected court on these issues. It hears important commercial disputes, shareholder disputes, and it's often looked to on corporate privilege issues. But at the same time, this is essentially the first type of decision like this that imperils communications that pass through third-party email accounts. Other courts and other jurisdictions could ignore it. Other judges in Delaware could kind of do that too, or narrow the implications of this holding, or try and distinguish it in other cases, so that so the implications of the case aren't etched in stone, but you can kind of see where we have our concern and how this could have some far-reaching ramifications. And I'll say this issue has come, I mentioned we've dealt with outside director discovery and other litigation we've dealt with, and we have claim privilege over documents that pass through outside director email accounts that are with third parties, and there's never really been an issue. Now we expect that the argument will at least be made by the other side. So I'll turn it over to this point to Matt and Ryan to talk about what are best practices and what types of questions come up after this decision.
Yeah, this case was certainly a bit of a shocker to a lot of us because I've seen many communications with directors and many directors that prefer to have emails sent to them at an account that you look at it and it's not the company account. It may be an account with some other place. So this could have some far-reaching implications, and I'm still not certain whether Delaware, in fact, got this decision right. Time is yet to tell, and as Billy was saying, it's very possible that there could be ways of narrowing this decision or distinguishing it, or perhaps Delaware may come out on in a different way entirely and in due course. But while we hope that day will come, there are a number of questions to consider and preparations that companies can make for the disclosure of privileged information to the board. The slide you have up there has a lot of these issues. And most importantly, I think the biggest issue is how is the company communicating with outside directors? And that's a question that companies should ask. It's not just the company and how people internal to the company are communicating, but it's also important to remember that it's outsiders, like outside counsel to the company. As outside counsel, we're often asked to send things directly to the board of directors, be it an agreement or a draft disclosure document for the SEC or a registration statement. And we could be asked to send those directly to the board. So it's important for outside counsel to be conversing with in-house teams to see what their preferred methods of communication are. And hopefully the in-house folks have vetted some of these things with their directors. It's also important, though, to look not just at how the board gets communicated to by outsiders, but how the board communicates with each other. And if you do everything right, you send an email directly to a director at an email account that's issued by the company, and a director takes that and forwards it and sends it somewhere else, it could cause a problem, even if it's to another account for one of the other directors. It could cause a problem unbeknownst to the company. So another question here is, how far will the WeWork case actually be extended? Right now, we're looking at email accounts, and certainly there are going to be litigants that are going to try to argue that it should be extended farther beyond just email accounts. The same principles might apply elsewhere. But I think, as Billy noted with a privilege log, it's something that is more readily apparent perhaps than other types of communications that people could argue would similarly come under this rule. And another important distinction is emails are particularly helpful for litigants because they contain so much information. There's usually a detailed discussion in an email, and then also there could be documents attached to it that go into more detail, and other types of communications that people might try to claim have waived privilege would likely not yield the same type of information. Well, at this point, I'd like to make sure we have Ryan on here with us so we can talk with us a bit about some of the things that he's seen at Goosehead. Ryan has been at Goosehead for a number of years and helped take Goosehead public about 3 years ago. Goosehead's publicly traded on NASDAQ, a company based here in Westlake. Talking with Ryan, I've been particularly pleased with how good of a job he has done in communicating and working with the board of directors. Goosehead became public at a time when a lot of the resources that are out there and available today in terms of technology were available, which I'm sure made Ryan's job a lot easier to become organized and do it in the right way. So why don't we flip over to the next slide and we can talk through some ways that companies can implement policies and try to protect their board. I think in privileged communications, one of the first methods is using a confidential portal. And I guess at this point, Ryan, do you mind telling us a bit about how Goosehead communicates with the board?
Yeah, thanks, Matt. And thanks for inviting me to join the call. We primarily use Diligent, which is a board management program. And we also have email addresses that are issued, with the goosehead.com URL for each of our directors. And while we don't have a written policy, we've trained our directors that there to use only their goosehead.com email addresses in board communications. And then, we obviously only send materials or communication to those goosehead.com email addresses. But primarily the way that we communicate, board books, including prior minutes, agendas, cues, slides, et cetera, is through Diligent.
I've heard that name Diligent quite a few times. I took a poll of several of my public company clients, and shockingly, all of them are using the exact same program, Diligent. And it was not at my recommendation. They all found the same place. Can you tell us a little bit about it and what it can do for you?
Sure. So when we first went public, we were looking for board management software. And we initially thought that we would just use SharePoint. We have a relatively small board and thought that would be easy enough. After looking at it, we realized that it wasn't quite secure enough. There were some things that SharePoint did because it's not created specifically for board management that we didn't like, including storing metadata and things about documents that you upload to SharePoint that we didn't necessarily want to be stored. So we looked around for a board management program. There's a couple of different options out there. And we actually went with a competitor for a year. And I'm not trying to make this a commercial for Diligent, but later looked at the software and the offering from Diligent and decided to move over to that platform 2 years ago at this point.
I know it sounds like an infomercial a little bit, but it's also helpful for people to understand, because I know that these confidential portals are something that's relatively new in terms of providing information and access to directors. So it's certainly helpful, I think, for a lot of the folks in our audience to hear about how some of these work. Can you tell me a little bit about the confidentiality and other things that you have through Diligent?
Sure. So Diligent is a cloud-based software. You can implement multi-factor authentication. And so that's obviously helpful for security. It allows you to upload slides, your minutes, our draft queue and other documents, earnings release, et cetera, for the board to review and approve. Because it's a cloud-based software, it can be accessible on any device. We've really, to full disclosure, we've only really tested it on a laptop and an iPhone and an iPad, but I'm assuming it works with Androids as well. But whenever we upload anything to Diligent, I'll have someone internally upload it. I will check it. Another internally will also check it to make sure that everything's accurate. And then we'll post it to Diligent. And then all of our directors will get an alert either on their iPad or iPhone, depending on how they set it up, and an email to their goosehead.com email address, letting them know that board materials are available. What's really helped us is I feel like we've gotten into a good cadence over the last 24 months. So our board, obviously, they know when the next board meeting or audit committee meeting will be, and they expect those board materials at least a week out. And we've gotten to a point where they start looking for that notification about a week prior to the meeting to know when those documents are available for their review. Another interesting feature is you can also have them fill out their annual D&O questionnaires through Diligent, which is very helpful. If they just have an iPad or an iPhone, they can easily go through that questionnaire very quickly, add what they need to add, change what needs to be changed, and then submit and actually apply an electronic signature through that process. So it's all kept in one place, which has been very helpful for us.
Excellent. So would you say it's been more helpful, or is it more of a burden to have to use a portal for communications with the board?
And initially, we did need to train our board. Again, one good thing about Diligent, to Matt's point earlier, is it is used pretty universally. So it wasn't a brand new software that the board had never heard of. We have two of our independent board members who serve on other boards, and they use the same software with those other boards. So they're very familiar with it. They understood how it worked. But it's been very helpful and user-friendly for us. It's a good way to keep all of your communications in one place, and to know exactly what the board's seeing and what they're doing with it. It also prevents the board from, forwarding that information on, at least inadvertently. Technically, they could print it out, scan it, and then forward it, but that would be a pretty intentional act. So it helps protect the information from that perspective as well.
And one common complaint that I hear from some directors that may not be as familiar with using this type of a system, or with having a company issued email account, which is a helpful way to protect the attorney-client privilege. One of the common complaints I hear is that I have too many email accounts. I'm not going to know how or when something comes in. I can't check every single email account. Have you run into those types of issues, or the ways that you can alert directors so they're aware that something is in their inbox?
Yeah, so we have a couple of ways of doing that. One is to rely on those notifications on an iPad or iPhone, but as you know, we all receive 200 notifications a day on our mobile devices. I have a pretty good relationship with our board members, and if we're sending out a one-off written resolution that they may be expecting but they're not necessarily looking for, I'll text them and let them know that that's been uploaded, and then they can go on and check it, and even again sign through diligent once they've read it and approved it. But I would say, and this may not work for every board, if your board is very large and maybe you don't have that kind of relationship with your board members for whatever reason, I feel like text messaging has really helped us communicate in addition to some of those notifications that go out.
Perfect. That's very helpful. So I think two of the recommendations we're seeing almost universally is, if you can, and it's not cost prohibitive, to switch to a confidential portal for board communications. And something that may not be too difficult to do is to issue a company email address to directors, like you said has done, to facilitate communications in that fashion. And another approach that isn't running against the decision from Delaware would be to have people use a personal email account, or just not an email account from another employer. So there isn't that question if you have a Gmail account or Yahoo account, something of that nature, where emails can be received, that may also not immediately run against the decision from Delaware. And companies can also consider prohibiting the use of email accounts by other companies directly, or here's another piece. If people are using a different email account for receiving board communications, they have a Gmail account, it may be helpful for that director to set up a unique account that is just for those board communications. That way, if there does happen to be a discover request, then that director does not actually have to go through and provide a whole bunch of personal emails in addition to relevant emails to someone to do a privilege review on them. All right, moving on to the next slide. We've talked through some of the best practices here for addressing the WeWork case, but those aren't the only things that can be done. There are other things that can help mitigate risks, not necessarily everything from WeWork, but they can certainly help. And the court focused quite a bit on whether any of the communications were encrypted, or attachments were encrypted, or steps were taken to try to maintain the security of the documents. So one thing that could be done if there are sensitive materials being distributed would be to password protect them so they are not accessible, even if the email happens to have been intercepted or inadvertently received by a third party. You can also look at entering into confidentiality agreements with directors, employers. That could help address some of these privilege issues and help show that there may be an expectation of privacy in those communications. It may not be as feasible, but particularly employers who may have portfolio companies and are asking employees to serve on those portfolio companies, they might consider addressing this through a change in their actual monitoring policy to provide that the company will not review board level communications, or those types of communications by their employees are exempt from the monitoring policy. And something that's always helpful, and we've been asked to do from time to time, is to go out and provide a privilege primer, much like what Billy gave earlier today, talking with directors about how they can help maintain the privilege for the company, and don't do things like forward them to outside advisors where it would not be protected. And it looks like we have a little bit of time left, so we can talk through a few additional issues that are similar to are raised by the WeWork litigation. And I think things are heightened a bit whenever we are looking at people who are serving in different roles. So like in WeWork, if you have someone who happens to be serving both on the board of directors and is also an officer of a company that's not the same company, but a different company, that's the type of scenario when you have potential for a problem. So you might want to focus more closely on those scenarios. And then I'll turn it over to Billy, who can talk through some issues that arise when you're dealing with board observers and shareholders.
Thanks, Matt. So I'll run through a couple of these issues quickly, and then we'll save a little time at the end for questions. So on sharing, a more common practice now is for stakeholders to negotiate board observer positions. This is not a position that's recognized by the law necessarily. Board observers aren't fiduciaries. They're kind of creatures of contract. They're generally entitled only to attend and observe board meetings. So a question is sometimes, or as we've gotten this from our clients sometimes, what happens if a board observer receives privileged communications? Is everything still privileged, or is there a concern there on waiver, which in the same vein as the WeWork case? So there was a case issued last year by a federal court that answered this exact question. I call it the Finjen case. Finjen asserted that SonicWall infringed some patents. Cisco had a board observer on the SonicWall board. There was a strict NDA between Cisco and SonicWall. Finjen claimed that privilege over materials shared or discussed with the board observer was waived. And Cisco in response claimed common interest privilege, like we talked about earlier. The common interest doctrine applied because Cisco was a shareholder. It had an interest in the litigation as a shareholder of SonicWall. And so the documents stayed privileged even though they were shared with the board observer for Cisco. The court did not, like I said earlier, there's a lot of different opinions on what constitutes common interest, lots of confusion over when it applies. The court here said there was no common interest. And the reason for that is the court thought, well, Cisco doesn't have an interest in the patents that were at issue in the case. It only had an interest as a shareholder. This is more in the nature of a commercial interest rather than a legal interest. So there was no common legal interest that qualified for the common interest doctrine. Therefore, disclosure to Cisco and its board observer waived the privilege. There was also a work product argument like we talked about earlier, since this related to ongoing patent litigation. The court denied that as well because there was no thought that Cisco would become a party to the litigation. So again, this is kind of a cautionary tale. Common interest doctrine can be applied narrowly sometimes, and you need to exercise caution in sharing privileged materials with third parties, even though you might consider them maybe the same party or as you, or like a shareholder in this instance that has a board observer, or in other contexts as well. And so just a few tips on how to deal with board observers. This is something Matt has some experience with. I do not in the practical sense, while you're actually discussing with board observers only on the back end when there's an argument about whether privilege applies. So I'll let him discuss this a little bit.
Thanks, Billy. Yes, on the transactional side, we do our best not to create issues for Billy to have to handle. But with board observers, I think one of the most important things to remember when dealing with a board observer, and it's something that sometimes we have to remind our clients about, is that when you have an observer on the board, that observer is not a board member. They're just an observer. They do not have fiduciary duties like board members do. So they need to be excluded from certain discussions. And observers are in dealing with private companies, they are oftentimes some of the most helpful people on the board because they have tremendous insights. They're often employed by strategic investors or have many investments that they handle. So they have really good insight about things. But it's important to remember that even though you are seeking their advice and you want their advice on a lot of different issues, the thing you don't want their advice on is something that's attorney-client privileged. So most of the forms that are out there for appointing an observer will include some type of language that allows them to have access to materials, but allows the exclusion of things that are privileged from the packet of information that they get. And they should also include language in there that allows the observer to be excluded from any privileged discussions. So it's important to have that agreement, but it's also important in practice to make sure that you don't provide those types of privileged documents or materials or let observers or allow observers to sit in on meetings. If you must disclose something to an observer that is privileged, you can try entering into a common interest and confidentiality agreement with them. But again, it's a best practice to not provide observers with that type of information. Billy, I think we have a few more minutes to talk about communications with shareholders.
Great. One related topic. What if a shareholder has designated a board member, an actual director on the board, and that director reports back to the company that designated it, him or her? Is privilege waived in that scenario? We've had this question come up surprisingly a lot. And I say surprisingly because there's not a lot of case law on the issue actually that gives a clear answer. It's a situation that comes up, but apparently hasn't been litigated all that often. So just a few thoughts on this. There's no case to discuss, but there's a line of Delaware cases that strongly says that when a director serves as a designee of a stockholder, the stockholder is generally entitled to the same information as the director. So, and that includes privileged information and communications. You would think on the flip side of that if a director is sharing privileged communications with the stockholder that designated the director, and the shareholder simply exercising that right, privilege wouldn't be waived. But again, no case law on this issue, and there's a lot of cases outside of Delaware there's a few cases outside of Delaware where the courts haven't recognized this type of argument and haven't allowed the privilege to apply, and they've found the privilege to be waived. There's a few other arguments you can make. The common interest doctrine may apply. We've already talked about how can be flimsy sometimes and not all that reliable. The joint client privilege may apply in some situations. Again, this raises difficult ethical issues sometimes. So it's something you may want to avoid. Where it typically comes up is where you have a parent company and a wholly owned subsidiary. They're considered joint clients of the same attorney. Sometimes you'll have not a wholly owned subsidiary, but a parent company with a majority interest in a subsidiary, but there's other shareholders. That's when some of the ethical issues can get tricky on the joint client privilege, or when you're selling or spinning off the company. And then, like I said earlier, some courts have found waiver under these circumstances. So best practice is to not share privileged communications or information with shareholders to avoid waiver. But again, there's some things you can do to mitigate some of the implications of sharing information with shareholders. And let Matt talk about that a little bit here.
So I think the best recommendation that we have in terms of dealing with shareholders is do your best not to share privileged information with them just as a best practice. It's oftentimes not necessary for them to have that type of privileged information. And you can remind board designees of their fiduciary duties and also share with them the consequences if privilege was in fact deemed to be waived, and how problematic that could be for the company. So I think our best advice here would be to do your best to not disclose that information. But if you do find yourself in a situation where you are disclosing it, enter into some type of a common interest agreement with them. Usually stockholders of this nature, if they have the ability to obtain privilege, or of the ability to obtain board documents, then they are probably going to be under some type of confidentiality agreement already, but certainly enter into a confidentiality agreement if you don't have one already. Looks like we have a couple minutes left for Q&A. And I'd also like to ask Billy, if you don't mind going back and just putting our contact information up there for everyone to see, just in case you all would like to contact us and we don't have a chance to get to your question. I think that the first question I see, and Billy, I'll let you take it, but what would the impact be if an outside board member primarily uses a non-company email address and has automatic forwards from his company email address to his non-company email address?
Yeah, so that's a good question. Again, the key things you want to look at here are who is ultimately going to have access to the email, and do they reserve a right to monitor the email. So if this director is forwarding the email to an email account that the third party company, the other company has access to, and they've said, we reserve the right to monitor this email, then yes, you, under the WeWork case, you risk waiving the privilege by doing that. Now, again, we've talked about there's might be ways around it. The privilege may still apply. It's kind of a fact-specific analysis, but that is kind of the exact scenario that raises the concerns that we had after we heard and read the WeWork case, because you then have a third party that reserves a right to monitor emails that are on its servers, and there's an argument that it loses its confidential nature by that fact.
All right, another question I see, and Billy, this may go in for you as well. What happens if someone's personal email account is hacked and by no fault of their own information gets disclosed?
Yeah, that's a good question. So I would say if there has been a hack, you have taken steps to maintain that communication confidential, assuming that the hack wasn't a result of some gross negligence or something like that, where you've given a third party access to your email and they've overstepped their bounds or something like that, some bizarre fact scenario like that. I think as long as you've taken steps to secure that privilege, then you are usually going to be safe. Where you might have some concerns if you've been hacked is that the emails are then published to the public at large, and then maybe you may still have privilege arguments, but the damage has been done outside of litigation, and it's almost impossible to undo that damage in other ways. So I would say that if something has been hacked, like a Yahoo Mail, you'd still probably be okay. But that's kind of one of the reasons we'd also say, after the WeWork case, I think the court came close to even blessing use of personal email accounts like Gmail and Yahoo, because you have sole access to it. But there are some data security concerns where if you are the company and you are allowing documents to go outside your servers and you no longer have control over it from an IT perspective, not only privilege, there may not be privilege concerns, but there might be some data security concerns there to think about before that's the go-to route you want to take for your company.
Thank you, Billy. It's a wealth of information. We really appreciate it. And thank you, Ryan.